biggest element is something that's not really out there, widespread, but it is a significant thing that is also growing in popularity. Hi, Jeff Marsocci, the Plain English Attorney, and welcome to the video. This one's actually going to be in two parts, and it's about protecting the kids from a potential divorce. Now, when you're putting together your own estate plan, we're going to talk about that as part one and what you can do to actually protect an inheritance that's going down to the kids so that it doesn't end up being claimed in a divorce. And for that matter, it'll also work for things like lawsuits, bankruptcy, and creditors against the children. So that's part one. Part two is going to be how you can guide your children and what they can do to protect themselves from divorce, because we've got some really good potential solutions on that end too. So, starting out with part one, the plan for your assets. Now, in order to do that, really, we're talking about a revocable living trust and the ancillary documents that go along with it. Now, revocable living trusts are a way of doing estate planning where you're keeping control of your assets during life, but it's set up so that if you end up becoming incapacitated or you pass on, well, none of that stuff actually has to go through the probate court process. Now, I suppose you could end up trying to do this with a will, and it ends up going through the probate court process. But look, if you're going to take these types of steps to help your kids and do some good stuff to help them avoid uh, all of the bad things in life that can come through a divorce, you might as well make sure that you're getting them as much as possible, avoiding all of the big four downsides of probate. Let's just take a brief minute and we'll cover that. The first thing, downside of probate, it's expensive. Look, you really should just kind of count on between 4 and 10% of an estate disappearing through legal fees, court costs, legal fees, appraisals, legal fees. Look, attorneys make a lot of money off of probate. It really is a kind of complicated process that requires a good knowledge to have it even go semi smoothly. And even then, it's not going smoothly. I've often said that being an executor for an estate is the worst part-time job you're ever going to have. And so the inclination to just say, let an attorney do it. All right, well, that's fine. If you're going to look at trying to avoid those costs up front, having a revocable living trust to avoid that on the back end just makes more cost-effective sense.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Second big downside for probate, delays. It is kind of a court process. It may not be as elongated as an actual lawsuit or a criminal trial, but it still has built-in time frames and delays, and stuff needs to get submitted to the court. It needs to be approved. It's just all of this paperwork tsunami that's going to just bring everything to a very slow pace. Whereas with the revocable living trust, look, debts are taken care of, taxes are paid, stuff gets distributed to the beneficiaries. Not a big deal. Third big thing, there are potential contests out there. And probate is a lot more vulnerable to being contested. Now, this is because the probate court process is set up so that, hey, we need to get this right. We need to get to exactly what was intended under the will or under the law. And so if somebody files some type of proceeding against the estate because some beneficiary doesn't like what they're doing, a lot of the time the attorneys are going to get paid out of the estate. So they're willing to roll the dice. If you're going to sue a revocable living trust, okay, that disgruntled beneficiary is going to have to come up with their own money to pay the attorney because it's not going through probate court. It's actually going through civil court to try to sue the trust, and therefore those attorneys need to get paid. They realize North Carolina and a lot of other states, it's just not going to end up being a slam dunk. Oh, will get paid from the other side or from the other party. That's just not something that generally happens. And then the fourth big downside, private information ends up being pretty public. So when you're talking about things being exposed to the public, look, when you're doing these inventories, there's the inventory. You have to list each and every asset, account numbers, date of death balances. You have to put out the names, ages, and addresses of all the beneficiaries, and it's public. Anyone can actually see those records. And so the marketing people will go through and get their information in order to fill out their marketing lists and start marketing to the beneficiaries that they know are going to be receiving some kind of inheritance. And a lot of my clients don't want that. That last one, that's also bringing up the potential that your child could be targeted by some Romeo or Juliet who's really just trying to get to them for their money. If they see there's a whole bunch of money going to them, that's just going to make them a potential target. So you're going to have that revocable living trust for, at the very least, the bulk. The majority of your assets are not going to end up going through probate because they're either titled in the name of the trust or pay on death into the trust. It stays out of that probate court process, and therefore people can't see it publicly. Right. Second big point is revocable living trusts are the conduit to get the estate to the kids the right way, but you're keeping control during life. So when you're setting up a revocable living trust, you're the trustor setting it up. You're the trustee. You're the first level beneficiary. If anything happens and you become incapacitated, well, you've got your successor trustees listed. They step in, they manage things for you. And so you're not giving up control and oversight to a court. It's all happening privately by the people that you choose. So they're taking care of you. Now, when you do pass on, or if it's a couple, when the second of you passes on, now we're going to be talking about the best way to protect it for the kids. The best way to protect your assets from getting claimed in a divorce against your child is that they don't have actual control over them. So what we're setting up, the revocable trust beneficiaries aren't the kids. We're setting up asset management trusts for the kids. So now these protective trusts are going to keep that from being something that could potentially get claimed in a divorce because they're not having control over it. So let's talk a little bit about the way these trusts work, because this is the critical piece. When the inheritance goes into the asset management trust, now suddenly it's protected. That asset management trust is now irrevocable and it can't be changed. Your child is the beneficiary, but they are not the trustee. Someone else is the trustee. And while they have the obligation to take care of the beneficiary, they are not obligated to actually give them money. So let's talk about the way these trusts work. It's all discretionary. The trustee can give them money or not. Now, one thing you should never, ever, 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 ever do as a trustee of an asset management trust. Oh, you want a house? Here you go. Here's the money. Go buy the house. No, 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 no. The asset management trust, if it has enough money to actually buy the house, the trust buys the house. The child is the beneficiary. They can live in the house. Oh, they're married. Fine, the spouse can live in the house. The marriage breaks up. Spouse is probably going to want half the house. This is my house. I live here. This is my house. I want half it. No, because your child never owned it. It was in the trust. It's as if it were somebody else's house and they were just being allowed to live there. They don't get to claim, I want half the house, because your child doesn't even own it. The trust owns it. And that really is the biggest way that these inheritances end up getting lost in a divorce, It's because they end up dumping in inherited money. And this is something that drives me crazy when I hear attorneys do this because it's so short sighted. Well, inheritances are exempt from a divorce proceeding. Blah, 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 blah. Yeah. But what ends up happening is people do stupid things when they're in love. That's just the way it is. Oh, you got all that money from your parents and that inheritance. Well, we can use that money so we can go and buy out our new dream house. And so they go out, they get a realtor, they end up buying the house. The realtor goes, "Oh, do you need a mortgage?" "Oh, no, no, we're paying cash for this." "Oh, okay." They get the information over to the closing attorney. They go, "Oh, well, they're married. It's going to be tenancy by the entirety, which is joint with the right of survivorship for married couples. Here's your house. Here's your deed. Isn't this great? You both own the house." And then a couple of years later, the spouse takes up with the personal trainer. They're running around and they go, "I want a divorce and I want half the house." Well, all the money for the house came from my parents. "Yeah, well, I talked with a divorce attorney and you commingled it. I'm getting half the house." They're right. If it's bought inside the confines of that asset management trust, they don't get half the house. It's never in your child's actual name. And now inside that trust, they can give them, $5,000, $10,000 here and there for vacations, for uh, other purchases, helping out with some bills, but not giving them huge amounts of money to buy the big things, because the major purchases should always be done into that asset management trust so that it stays there and it stays protected. And again, this is all whether they get the money, how they get the money out, it's all in the discretion of the trustee. So you've got to be very clear with the trustees that you're picking. Here's how we want things done. And because of longevity issues, you probably want a trust company somewhere at the bottom of the list just in case things get really nasty. Well, now the trust company can really lock things down, and it's not some friend or family member being put in the middle of some big, huge uproar in the middle of a divorce. It's a company that's handling it, and they're going to protect your child because they're a fiduciary. So all those major asset purchases, yeah, that happens into the trust, not outright. Now, this is a little bit more on the emotional level, but look, if the money is in the trust and someone else is the trustee, it's also going to help your kid just tell their spouse no when they want money out, because your child isn't actually the trustee. They can always use the excuse, "Oh, well, look, I went to the trustee. They said I can't give you the money. This isn't something that I'm going to approve." And now your child can also always say, "Look, my mom and dad wanted this money to be here for me, but they eventually want it to be for our children. You don't want to take that money away from our children. So the money will go to our children when I'm gone." And that's just the way it is. It actually helps smooth things over if you can blame the attorney, if you can blame the trust company or the trustee. "Look, sorry, I can't just take out another $80,000 to get you that brand new car that you wanted or that expensive piece of jewelry. Sorry, can't do it." Now, that's not the only protective piece. So you've got these asset management trusts that are going to be there throughout the lifetime of your child. When they pass on, it goes down to the grandkids. Well, what if they don't have grandkids? And this comes up, say you've got three kids, only two of them have children themselves. Well, then it can go to the other two kids' asset management trusts and eventually down to those grandkids from that side. So that's all in there as well. It's very typically. Now, you can make the beneficiaries really whomever you want. But if you're trying to protect your child against a potential divorce, this is one way to do it. Now, the other components, are IRA trusts. And this is really for when a lot of my clients, they do have some extensive assets that are tax deferred, IRAs, 401ks, or even tax-free Roth money. You want to make sure it's handled the right way and it's still protected. So this is where we also have an IRA trust for each child. Now, how do these IRA trusts work? They have all of the quote magic language that the IRS says needs to be inside an IRA trust in order for it to be treated as a person. So, unfortunately, I'm sorry, I'm going to do this as quickly as I can, but we got to talk about taxes. Okay. When someone receives an inheritance as the beneficiary of a retirement account, so let's just say, okay, mom passed on and she left their child, they named them as the beneficiary on their IRA. Well, okay, that child can take the money out, pay all the taxes, done. Well, that's a huge amount of taxes because it's 100% income taxable. It all goes onto their 1040 in that 1 year. No, 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 no. We don't want to do that if we can avoid it. Well, what can the individual do? They can set up an inherited IRA, move the money in, and now they have 10 years to take that money out over that 10-year period in their discretion. It's just it's all going to be out by the end of the 10th year. All right, well, can't we just have it go to that revocable living trust so it filters down to the asset management trust? Yeah, you can, except now it's a 5-year even schedule. There is no discretion to take more out in 1 year and less in the next, and it's half the time. So it's a much shorter period of time, which means it's more likely to push you up into those other tax brackets. So depending on the size of those retirement accounts, you're probably not going to want to just name the revocable living trust, more or less. If really you don't have a lot of tax deferred assets, it might not make that much of a difference. But usually when we're doing this setup and we're looking at the retirement accounts and you're trying to protect it for your kids, a lot of my clients do have sizable retirement accounts. So we also set up an IRA trust for each child. So now the IRA trusts get treated as an individual, except the trustee is the person who is in charge of it. So it goes into the IRA trust inside an inherited IRA that the trustee sets up. The trustee pulls the money out of that inherited IRA account, which is inside that IRA trust, and it gets taxed. And then over that 10-year period, once those taxes are done, taken care of, paid, and all that money is being reinvested in other taxable type accounts, brokerage accounts, mutual funds, whatever, then after the end of the 10-year period, the trustee can move it over to the asset management trust for that corresponding child. So these IRA trusts, they basically have a good shelf life of 10 years, providing the same exact type of protection against divorce lawsuits, creditors, and all those other bad things as the asset management trust, but it's only going to be for 10 years, and then it's going to be combined with the asset management trust. And that's the way you're going to end up protecting your kids from these potential divorces. Now, like I said, it can be a really big concern if you see your child and there's a son-in-law or a daughter-in-law in the picture, or a future son-in-law or daughter-in-law coming into the picture, and you really just don't have a good feeling about it. All right, at the very least, you can protect what you're leaving down to them through this type of setup. So that's really part one. So now you've got these asset manager trusts, the IRA trust, you've got your revocable living trust. What about part two when we're talking about the kids and what they can do? Well, now we're talking about a whole other strategy from a different perspective. We're talking about this perspective of the child that's putting together their own type of plan. So what we really need are a couple of different elements. Now, the biggest element is something that's not really out there, widespread, but it is a significant thing that is also growing inside, that's growing in popularity. This is where we have the domestic asset protection trust. It's not available in all states, but you can get it tied to a particular state. Now, the one that I use most often, just because I'm a lot more familiar with it, is Wyoming. So under Wyoming law, you can have a domestic asset protection trust. You can have a trustee. And this trustee is the person who's in charge of saying yes or no to the beneficiary, kind of like the asset management trust. Except, and this is the big difference, this is where your child can put money into this trust over their lifetime and during their lifetime and still have it be protected from lawsuits, divorces, creditors, bankruptcy, all that other stuff. It's happening inside this domestic asset protection trust. This is also very, very critical if your child is really going to be going somewhere, they're building their own business. Well, this business can be formed and stay inside that domestic asset protection trust. So the domestic asset protection trust can put a wrapper around the whole thing and protect them. Well, that sounds really great. What are the limitations? There are some. And you really do have to stick to what these limitations are. So if you're the child, your child is putting this domestic asset protection trust together, they're putting their assets into it. Maybe even they're starting a business. Well, the LLC is owned by the trust. The business operations happen within the trust. The trustee is the only one who can say, okay, let's just say it's Jim Doe. It's John and Jane Doe did their plan. We've got Jim Doe. He's going places. He's got his business. It's formed inside a domestic asset protection trust. Jim Doe wants to just withdraw $50,000. They can't just go to the bank and pull it out. The trustee has to be in charge of whether or not money comes out of the trust. That's just the way it has to be in order to get all those protections. So the trustee can veto and say, no, I'm not giving you any of this money. You can't have it. Well, okay, that's the reason for doing that is to make sure that it is protected. Well, what about that business inside? Well, look, that LLC was formed. It's owned by the Domestic Asset Protection Trust, but that doesn't mean that Jim Doe can't be the manager, can't handle all of the operations. In fact, Jim Doe can be the investment manager. Jim Doe can basically run everything, including the investments and where the money goes inside the trust. But it takes the trustee to say, yes, you can pull money out yourself. You want to just make sure, be very, very clear and above board. Okay, well, what is Jim going to do? Jim Doe going to do for money? Well, okay, he's got his business. There's a contract between the LLC and Jim Doe for his employment. And so he gets these certain pay and he gets whatever bonuses and benefits and whatnot for running the LLC. And we're going to have the trustee sign off on it on behalf of the trust because remember, the trust owns the LLC. All right, so that's the contract with Jim Doe. And now we also need, and this is a component that's specific for Wyoming and many other states. There has to be at least one trustee within the state of Wyoming. Okay, all it really takes is a person with some type of address and they have to have some kind of minimal responsibilities. Usually we put to, quote, cause the tax returns to be done for the trust. Okay. And you have to have some kind of assets within the state of Wyoming so that it definitely does have some assets in the state of Wyoming. I don't remember the numbers right offhand, but it doesn't really have to be all that much. Now, there is one more thing that Wyoming requires that other states may not, or they may have different things. I believe it's a $1 or $2 million insurance policy against personal liability. This is just to prevent someone from going absolutely nuts and causing a lot of harm to people. And it's like, haha, you can't sue me. Well, okay, no, they've at least got this insurance policy that can cover personal liability things for the person who's acting that way. Thing is, most people with money who use this type of trust, they're not going to be acting that way. So that's the Domestic Asset Protection Trust. Well, wait, how is this really happening with divorce? Well, look, it's all part of an overall plan. If your child really wants to be protected against the potential for divorce, other than not getting married, Okay, set up this domestic asset protection trust and put money into it. Now, this does require work along the way because when you're talking about relationships, in a lot of cases, people don't use logic and reason. It's, oh, we fell in love, we're doing this, and we want to get married. Well, how are the bills going to get paid? Oh, we'll figure it out. No, 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 no. This does require a little bit more discipline. If you're in that dating stage and your child's getting serious, they should be telling that person, hey, before we just say, all right, we're exclusive and this is, we're really pursuing a long term relationship, you need to know that I am never going to get married without a prenup. Now, that may screen a bunch of people out, but look, so be it. A prenup really shouldn't be looked at as, oh, this is the divorce document. You're looking for us to get divorced down the road. It's like, well, no, it's just there's a 60% chance that we are. Look at the prenup as a strategic plan for the marriage, because a prenup just doesn't say, okay, if we get divorced, here are the 5 or 6 things that happen. No, no, no. A premarital agreement, a prenup, lists here's how we expect that bills are to be paid. Here's how working is going to be paid. What happens if kids come into the picture? How do we raise the kids? What happens if we decide that you don't want to work anymore? No, I'm sorry. It says in here that both parties anticipate that they're going to work and continue to work. That's what we'll jump back into that in a minute. But that's the premarital agreement. Really, is how is this marriage going to run? And honestly, two people really shouldn't be getting married if they're not going to have serious discussions about all of those things that end up being in a premarital agreement anyway. Why should they even think of getting married if they're not going to talk about that things? It just doesn't make sense. So if when they're about to get exclusive and they're talking about, look, I'm not going to ever get married without a prenup, you need to decide right now if you're in or out. Okay. All right. Okay, fine. More time goes by, and now it's all right, let's try this. Let's move in together. Your child should be saying, I am never moving in with anyone without having some type of cohabitation agreement. And what's in a cohabitation agreement? Because you don't hear about that nearly as much as prenups, and usually it's because cohabitation agreements are a lot more rare, and people start thinking about prenups 2 or 3 months before getting married. It really shouldn't be that way, but that's the way people think about it. Now, a cohabitation agreement is a lot of the same things that we're talking about with the premarital agreement. How's the rent going to be handled? How are the certain chores going to be handled? Who's going to do them? How are we contributing towards the household expenses? And this is the big one: acknowledgement that domestic asset protection trust exists, and that after each of you have contributed to whatever that household income is, you get to do whatever you want with your own money, which, if it's your child, they should be putting it into accounts and investments and other things inside that domestic asset protection trust. So if the relationship breaks up and, well, I'm going to sue, you have all this money in this trust. Well, yeah, but you knew about the trust and you acknowledge that everything was separate. It's really tough for them to come back and try to get that money. They and it's off the table from lawsuits anyway, because it's in that really sewn up tightly trust under the discretion and control of another trustee. They can't get the money out without the trustee, and the trustee's going to say no. Right? So you've got that cohabitation agreement. If they're like, I'm not going to sign this, well, then you move along. But if you do, going from the cohabitation agreement to the premarital agreement is not a huge leap. They've already kind of gone through a lot of the process. It's just, okay, now we understand this is how it's going to work in marriage. And a lot of that same stuff is in there. It's just now we're also talking about the potential for alimony, what happens when kids come along. In both of these cases, if they just decide, okay, we're going to have a cohabitation agreement and we're never going to get married, or if it's a premarital agreement every 3 to 5 years, you should be readdressing and looking through those agreements to make sure they still fit and see if there are any adjustments or if there's a major change. Now, here's one of the major changes that does happen. It happens all the time. You both anticipate you're always going to keep working, that nothing is going to stop you both from working full time. And then the first kid comes along. Oh gosh. Okay. And now suddenly one of them is going to be a stay at home parent for a period of time. And then they're like, yes. And after that, I will go back to work. Are they going to go back to work part time or full time? Look, that's at the point where you're saying, okay, we can't do this full time thing for both of us anymore. All right, well, you need to reflect that in that premarital agreement that here's what the new deal is. I mean, it makes sense. If it's okay, we each keep our separate property, no alimony, no nothing. Well, now if one party is going to be staying home and helping raise the kids for a period of time, how long is that going to be? 2 years? Three? Until they go to kindergarten? You need to spell that out. And correspondingly, they're not going to be working and accumulating separate assets anymore. So what's the percentage going to be paying towards the household account? Well, okay, that's going to all fall on the other person who's working full time. Well, what if those 4 years come? It's like, I don't want to go back. Well, okay, well, look, it's in the agreement that you have to. And now you have an agreement and everybody knows what's anticipated. You can't just make it up on the fly. But again, one of the most important things that's inside that premarital agreement is any separate assets just go over into that domestic asset protection trust. It lists out here's what the trust is. And depending on when you each have your own attorneys, and you should always do it with each party having their own attorneys, it's going to be how much needs to be disclosed about what's in the trust. If you can just get away with, we're not going to disclose what's in the trust, but it's there, and this is where I'm going to be setting a lot of my separate money. Okay, you agree to it or not. So this is the way that your kids can be setting themselves up for success. Now, I do talk a little bit about this more. I'm going to be updating the book, but currently it's the divorce firewall strategy. And you can check out that book at divorcefirewallbook.com. And it runs through the different aspects of this strategy and some of it in a little more detail, particularly what goes into a premarital agreement that is working in conjunction with the Domestic Asset Protection Trust. So tying it back together, parents, you have your plan. You can have the revocable living trust. It pays into asset management trust for each of your kids rather than going to them directly, so it stays protected for their lifetime. And look, the simple fact is, if you've got 3 kids, one or two of them statistically is going to end up in a divorce if they get married. All right, you don't want what you're leaving them to get eaten up in a divorce or be vulnerable. And there's the IRA trust that will help with the taxation issues before the money goes over into those asset management trusts, and it protects it for that 10 years. That can be your setup. If you want more information on that, we have the inlawplanningwebinar.com and inlawplanning.com has the actual paid course. And now on the domestic asset protection trust and the child side, they can have their own domestic asset protection trust. Yeah, it's more complicated, and we got to work with whatever state allows the domestic asset protection trust, and got to have some kind of ties to it. You don't have to move there, but you got to have some ties there. And this is something that you could do and should do while you're single if this is a major concern. And then make sure along the way, in whatever the relationship is, if you're moving towards marriage, you have first the cohabitation agreement and you have the premarital agreement. And just a tip, at the point where you're talking about exclusivity, make it well known, look, I am never going to get married without a prenup. That's just the way it is. Decide if this is something that you're still okay with. And don't be highly offended or go, oh my gosh, okay, I won't do it. No, look, if they're going to walk away because you would be requiring a prenup before getting married, then they're not the person for you. If protecting against divorce is a big thing for you. Right. So that's part one. Part two of the strategy. Uh, this is a good amount of information. We do have some other, as I mentioned, we do have some other resources on this. So this is something that we're probably going to be talking about a little bit more, just because it's becoming a lot more of a need. You're seeing anytime there's uncertainty in the economy, people get a little bit more antsy and they become a little more sue happy. That's just the way it is. So this information is hopefully a way that you can proactively protect your kids from a divorce, and your kids can help protect themselves. So I hope you enjoyed that information. If you've made it this far, look, please hit that subscribe button, like the video, share it with people who need to know it, and put comments in about whatever you think is important. If you think there are any other topics we should be talking about, help this video get out there. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.